morning. Welcome to Law Power Hour. Today I'm on the show by myself. My guest called 5 minutes ago and said he was unavailable. Well, it happens now and then. But I guess I anticipated for this because I prepared an interesting show to talk with my guest about. It has to do with statute of limitations. And the statute of limitations is the period of time which an individual has to file a lawsuit. If you do not file the lawsuit within the statute of limitations, you're time barred from filing the suit. For example, if you have a personal injury claim, such as a slip and fall claim, the statute of limitations is 3 years from the date of the event. So that means you must bring your suit within 3 years or you're time barred. If the statute of limitations involves a claim for an automobile accident, good morning.
Hello.
Hi, how are you?
I had an interesting question concerning the statute of limitations for automobile accidents. It's my understanding that you have 3 years from the time of the accident for one party or the other to submit a settlement offer. And if not, your lawsuit is thrown out.
It's time barred is what the term is, yes. So your question is, what should you do? You should start your lawsuit within 3 years. Otherwise, you're precluded from making a claim for your injuries. If it's a no-fault claim, you must perfect that claim within 1 year from the date of the accident for your wage loss, for your attendant care, for your medical expenses, and lost wages. Is that what you were asking about?
Yeah, I think so. He's gone.
Well, having said that, we'll go into it in great detail. What the gentleman's point was, if he's involved in an accident, say in 2015, on April the 15th of 2015, how long does he have to perfect his claim? Either he or she must resolve their claim by April the 14th of 2018, or the claim will be time barred on April the 16th of 2018. So what you should do is, if you're negotiating on your own with an insurance company, you should resolve all your differences and make sure that you have enough time if you need to consult a lawyer within the appropriate statute of limitations. If you're making a claim to get your wage loss benefits paid from your first party insurance carrier or from the state fund, you have to perfect that claim within 1 year. The statute of limitations does not run after you perfect your claim until you receive a denial letter. A denial letter means that they're not going to pay your claim, or they tell you that the claim is under investigation. Then you would be required to perfect the claim. Good morning.
Yes. On that same issue, I was understanding that the city has filed a lawsuit to make no fault unconstitutional. If that happens, what would those people who had filed under no fault have to do?
Those people who filed under no fault would still have their claims viable. This is a very good question. They would still be alive because the law would only be prospective. to the extent that the law passes. And with respect to that law, what they're really talking about in that law has to do with the practices of the insurance companies as it relates to rates, because the rates are not even-handed. If you live in Oakland County, you're going to pay less than you pay in Wayne County for insurance. If you live, for example, as they pointed out in the newspaper article at Free Press the other day, if you live in Grosse Pointe, you're going to pay less for your insurance you're going to pay in Detroit. Now, I live in Oakland County. My son lives in downtown Detroit. His insurance is 2.5 times in downtown Detroit what he would pay in Oakland County for car insurance. It doesn't make sense. That's why 60% of the people in the city of Detroit are uninsured. They can't afford the insurance. And that's why the mayor started the lawsuit, because the purpose of no fault was not to create a barrier to having insurance. It was to assist individuals to make sure that they did have coverage. And that's where the constitutionality issue is coming up. What the mayor, through the lawsuit, is seeking to do, he's seeking to have the insurance commission and the insurance companies work on equalizing the insurance premium rates. And he's hoping with the lawsuit that within 6 months that the rates will be equalized so that insurance will be affordable. Right now, if you don't have insurance and you're involved in an accident, you're the driver of the car, you're out of luck. You can't make any claim under the statute the way it's written. If you don't have insurance and you're driving somebody else's car, you can make a claim. But you could also get a ticket for driving a vehicle without having insurance. It's a little complicated, just requires calling a lawyer, as I said before in my show. If you have a question about insurance or automobile no fault, we're a servicing firm. We answer those questions. I want to thank the gentleman who called a couple weeks ago with questions about his accident case. We answered his questions. I know we gave him information that he could use to help fill out his forms. So if any of you have questions, feel free to call our office at 1-800-LAW-USA1 or at Keller and Abenanka 248-335-9266. Now, just to finish that note, on the statute of limitations, if you're involved in an automobile accident with a governmental entity, or if you're involved in an accident involving the state highway, there's a notice provision, N-O-T-I-C-E. I hate to use the term notice and spell it out, but I want you to remember that you have to give statutory notice. You have a very limited time to give statutory notice to a governmental body. And let me give you an example. If you have an accident with a fire truck, and the fire truck goes through a red light, they don't have a siren on. There's no audible warning. You still have to give statutory notice. If you can't give the statutory notice, someone in your family has to give the statutory notice for you. I've had cases where people have been unconscious, and members of their family still have the responsibility of giving the statutory notice. If you have a road defect case, you must give statutory notice. And in order to give statutory notice, you should consult an attorney who will explain to you the procedure for giving statutory notice. If you don't give statutory notice, you may be barred from making your claim. I'm going to come back in a minute and we're going to talk about notice in medical malpractice, because that's a 2-year statute of limitations, and we do have a right to make claims, but we have to follow a specific procedure, which I'd like to go over with you. I'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
I started to explain to you in medical malpractice, in any area of professional negligence where you're dealing with a healthcare professional, there's a 2-year statute of limitations. And for the listeners out there, I want you to pay close attention to this because it's really, really important. If you go to the pharmacy and the pharmacist gives you the wrong prescription and you get sick, it's a 2-year statute of limitations to sue the pharmacy. If the pharmacy tech makes a mistake, it's still the same 2-year statute of limitations. If you make a claim against a physical therapist, it's a 2-year statute of limitations. Make a claim against a dentist or a chiropractor or a podiatrist or a nursing home or a doctor or a nurse or a nurse's aide or an LPN, it's still a 2-year statute of limitations. But there's an additional requirement. When you make a claim for professional negligence of any kind against someone in the medical profession or related to the medical profession, there's a pre-suit notice provision that requires you to file a notice of intent. And in order to file a notice of intent, you have to have 182 days before the statute of limitations terminates in which to file it. So let's say it's a medical malpractice claim that occurred in October of 2016. You would have until October of 2018 to file your notice of intent. And that would hold the statute of limitations in abeyance for 182 days. And then you would have to file an affidavit of merit signed by a professional along with a lawsuit setting forth your claims against the professional. But the law defines all medical personnel as coming under the umbrella of the medical malpractice statute. So it's a 2-year statute of limitations. If you want to sue somebody for libel and slander, where somebody has made defamatory remarks about you, or they've held you up to ridicule by saying that you've got some kind of disease like sexually transmitted disease and you don't have it, or you have AIDS and you don't have it, it's a 1-year statute of limitations. That would be the libel and slander claims. If you want to sue under liquor liability, in other words, you're injured as a result of somebody leaving a bar drunk, and they get in their car and they cause an accident, and you're able to determine the bar that they were in, you have a claim under the liquor liability law in addition to your injury claim. The statute of limitations for the liquor liability claim is only 2 years, whereas the automobile negligence claim is 3 years. However, with respect to the liquor liability claim, you must give notice. There's a 60-day notice provision in the law. You're required to give notice within that time of your claim. That's why you can consult a lawyer, and a lawyer will explain to you what you have to do. You can give the notice yourself, but you should always check with a lawyer to make sure that the form is correctly filled out, you're giving the appropriate notice. Because courts are very specific in notice provisions and following the law. Good morning. Hello,
Good morning.
how are you?
I'm fine. What I'm calling for, TV down. Okay, what I'm calling for is not about a right to bear. It is what happens if you have. I'm going to take it back here.
What happens if what?
When you have an attorney that you have, I know it, okay, let me put it this way. You have an attorney, and it's not your attorney, but the other party's attorney, and him and the judge is partners or whatever. Is the statute, is there a limitation or what you can do when you're once you're out of court to go back, because the judge is supposed to be equal and fair to all parties. But if you find that he's a one-sided person on all of the cases, what or length of time, or if any, or anything you can do once you're out of court?
Okay, the judges have a certain level of immunity. So what you first should do is file a claim with the Judicial Tenure Commission. You can go to a website and you'll find the Michigan Judicial Tenure Commission. You file a complaint with them and request an investigation. And at the same time, you can file a grievance with the State Bar of Michigan against that attorney and request an investigation.
Okay.
And that's how you start the ball rolling.
Okay. So now, are there fees for all of these things?
No, they're free.
Oh, okay.
They're absolutely free. But I'm going to tell you something really important.
Okay.
If you're going to file a claim against a judge or an attorney, be factual.
Okay.
You understand what I mean by being factual?
Yes. If you have all of your paperwork and all of your proof of things that have came down the line.
You got it. You understand exactly what I'm talking about. You know,
right.
you can't file a grievance because the other attorney didn't smile at you. I'm being kind of silly.
I hear you.
Silly saying that. But if all attorneys have to treat you with respect, regardless of whether you're their client or a client of the other side when you're in litigation. So if you haven't been shown respect as a human being, good citizen, regardless, it may be grievable. If
It's not the respect. It is the endings of every time you turn around. If you have an attorney client taking you to court every 3, 4, or 5 months, well, I'll just be blunt with it. For say, instance, in a divorce case, once you're done, how are you made to pay the other client's lawyer fees?
Post-judgment proceedings. They can go into court and seek enforcement in post-judgment proceedings if attorney fees haven't been paid. And
if
that's
they have been paid, now my thing is just say 2015, everything is cleared. Now you go back and claim, well, you're not doing this, you're not doing that. All of those different type of things that's not factual, but you can prove that they're wrong. And so now this same judge has been Judge 1 all the way to the end. Now they say, well, oh, you have to pay that person's attorney fee.
Well, if you're not compliant with the order of the court, let me give you a little phrase here. The court speaks through its orders.
Okay.
And those apply to you and me, not just to you, but to you and me. I'm an attorney, and I got to follow the order of the court. If I don't like the order of the court, I should file an objection to the order of the court, and I have a right to file an objection to the order of the court. I have 7 days from the entry of that order to object to it if I don't like it and request a hearing. But if I'm wrong, I'm going to have to pay the other side for their time in going to court. Now,
Okay.
if there's a judgment of divorce and you're required to pay X number of dollars over a period of time and you don't pay it, and they have to go into court to enforce it, then you're going to start paying costs.
Okay. Now, that's where the rubber meets the road. Everything has been done that the judge say do. But now you come back and say, oh, he was supposed to color my nails. That wasn't in the agreement. But yet your attorney requests this same judge on everything from 2011 all the way up, even though everything has been closed, and
Well,
now you come back and say, well, oh, he didn't buy the fingernail polish.
well,
That's not in the agreement.
no. Fingernail polish won't do it. But if somebody's out in the street and you were married to them and they're destitute now, and there's a change in circumstances and they need support, there are special circumstances where you could be required to come back to court. I'd be more than happy to answer your question off the record if you want to call me on Monday, okay?
Okay, their number?
248-335-9266.
Okay, thank you so much.
Okay, and anybody else who's got an off-the-record question, just call my office, Barry Keller, and we'll get to you within 1 or 2 days, okay? Good morning. Hello,
Good morning.
how are you?
I'm doing well.
How can I help you this morning?
I just have a question stemming off the previous caller about the attorney grievance process.
All
I
attorneys.
filed an grievance with a lawyer that I have,
Okay. All
and I
attorneys.
got a response, and he responded and denied everything.
And denied.
Yes.
Okay, well, you have
So,
are you going to a hearing?
she resigned from my case, and I'm in a position of pro per now. And I understand that I'm my own attorney.
Well,
Is that correct?
I don't know what kind of case it is.
It's a civil case. It was a auto accident case.
Okay, well, being pro per is not a good position to be in for anybody in an auto accident case because there are attorneys on the other side, and you need guidance.
Well, I have a settlement conference approaching,
Okay,
and I've tried to reach out to another attorney, and no one wants to assist.
well, you know, there are circumstances where you put yourself in a pro per position, and I don't know all the circumstances, and I'm not going to ask you all the circumstances out of respect for you on the air.
Thank you.
Okay, but I'm going to tell you this. I'd be very happy to answer your question. My number is 248
Yes, sir.
335-9266. And I'll
Can
help.
you repeat that, please?
That's 248-335-9266. And I'll be happy to help you find an attorney.
Thank you.
However, if the reason that you're not finding an attorney is that you're not listening to what attorneys are telling you, and it makes sense. I'm going to tell you that you're going to have a problem getting an attorney.
I've already run across that.
Okay, so I just want you to know that up front, because I've had instances in my own practice where we've made agreements to resolve claims with the judge participating, and I have clients who change their position, and then unfortunately my hands are in my lap because I can't do anything because we've already made an agreement. We put it on the record. So I don't know all the facts, so I'd be happy to go over it with you. Thanks for calling.
Thank
I didn't mean to cut you off at the end there, but I had another call coming. Now, I want you to understand a few things here. If you call a lawyer and you ask the lawyer for advice, the first thing you should get from the lawyer is kind of a guide, as I pointed out before, from the lawyer. Not, come on in, pay me a fee, and then I'll tell you how I can represent you. First, find out if the lawyer knows enough and has enough information to assist you. Good morning.
Good morning.
Hi.
Yes, I was trying to find out what qualifications are necessary for you to be a case manager under the no-fault insurance law.
You have just struck a chord on my favorite musical instrument. As far as I'm concerned, you need a medical background to be a case manager. You should have at least an LPN certification in order to be a case manager. And you got to understand, this is a prejudice on my part. Because I think there are a lot of people out there claiming to be case managers that aren't case managers. I manage cases for my clients, and I have 50 years of medical legal practice. And I can tell my clients with infinity what type of physicians they should see, what type of treatment they should have, and I direct them on how to get that through their primary care physicians. If they have problems in transportation, I work with the insurance company to make sure they get the transportation. If you've got a case manager who has no credentials, you don't have a case manager. You got somebody who is siphoning off part of your money, and they're not worth their services. So you need people who have training and background. There are qualified people out there if you really need a case manager. If you want some more information on that, you can call me at 248-335-9266, and I'll assist you in determining whether you need a case manager. Okay?
Thank you very much.
Good morning.
Good
Hi.
morning.
How you doing?
All right, good. No, I just could you explain the difference between executive attorney, the power of attorney?
Okay, well, power of attorney is a good question.
Not there. I'm hang up, not there.
You know, that was a real good question, and I'll tell you why it's a good question. This month is National Will Month, and everyone who has a will should have a power of attorney along with a will. With a power of attorney, and there are two types of power of attorneys. There's a durable power of attorney, and there's just a plain power of attorney. But with the power of attorney, you're giving someone the right to act in your behalf, to exercise judgment, and to handle your affairs. And power of attorney should be executed very carefully. They should only be given to people that you trust with your life, because that's basically what they're doing. You're giving them the authority to go to your bank, to handle your transactions, to help you pay your bills. You're giving them access to your financial information. And when you execute a power of attorney, that power of attorney is good as long as you're alive. When you die, the power of attorney extinguishes. And the person who has a power of attorney has absolutely no authority over your affairs. So what you're doing is you're saying, I'm going to substitute myself for another person, myself for another person who's going to make decisions for me if I can't make decisions, or who's going to assist me in making decisions. Now, if you have a medical power of attorney, you're authorizing another person to make judgments about your care in the event that you can't make a decision about your care. And that's a very difficult area to get involved in unless three things occur. Number one, the person who's entering the medical power of attorney, or the power of attorney for that purpose, is coherent, understands completely what they're doing when they're doing it. I had someone come to me last week and they wanted a power of attorney. They said their father had Alzheimer's disease, early stages. I wouldn't allow them to get a power of attorney until they came in the office to make sure that the level of dementia was such that they were not incapable of making decisions. Good morning.
Yes, you answered that one question. But what about somebody exec over you? Now, I'm going to listen.
Okay, wait a second. Somebody has what?
If you're executive over your thing.
Okay, well, your executor over an estate is a little different situation. The purpose of a will is for the dispositive disposition of property. In other words, to dispose of your property after your death. So the person that you appoint as the personal representative or the executor of your estate, you're giving them the authority to make decisions on how your property should be disposed of. Now, you can put in your will that it should be supervised or unsupervised. In other words, that it should go through the court or doesn't have to go through the court. If you put in it goes through the court, then the court's going to watch over everything that the executor does. And the executor of your estate has a lot of authority. When you draw a will, if you give the executor of your estate the authority to dispose of your property, he or she is going to be able to sell your car, sell your house, dispose of any assets that you have, and then they have a responsibility of distributing those to your heirs in an even-handed manner. So when you draw a will and you appoint a personal representative or an executor, you should be sure in appointing that individual that that individual is fully capable of acting as if you were standing right there and making your own decisions, because you want to make sure that that individual carries out your intentions. And that's where we get into the term dispositive disposition, disposing of assets after a person dies. Because the will does not take effect until the person has passed on. I got to take a break for a minute. We'll be right back.
you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
You know, there's a few things I want to talk about on limitations of action. If you get sued on a debt, the statute of limitations is 6 years. But if you pay on that debt during that 6-year period, it extends the statute of limitations. If you have a judgment taken against you and you don't answer, it's a default judgment, that judgment's good for 10 years. Good morning.
Good morning. My question is, if you're designated as the power of attorney, can you be the executor of the, executor, I'm not saying that right, of the will also?
No, you're saying it. Executor. Yeah, you can
Executor.
be. You can be both.
Okay. I did not know that. I thought you couldn't be, thought you could be one or the other.
No, you can be both. But if you're the executor of a person's estate and you're not related to that individual, then you're limited in what you could receive by way of a gift if there are other heirs.
Oh, really? Now, this person doesn't have any children. Okay, but this ain't, what is the limitation?
Well, it's kind of complicated. Do you have the paperwork is already drawn?
No, they're in the process of doing that now.
Okay, if you call my office, I'll give you the name of a good lawyer who really specializes in this, and she's phenomenal, and she'll help you walk through it. She's been on my show before.
Okay, and the office number is?
It's 248-335-9266. Her office is located in Lathrop Village, and she's phenomenal. I called her on a Thursday one time. People needed power of attorney for a person who was dying of cancer, needed some other matters taken care of. She just got right there and took care of everything. I'll be happy to share her name with you. If I'm not in, you call and ask for Adrian, my assistant, and tell her you want the name of the probate lawyer who's appeared on my show. Okay?
Okay, 335-9236, is that what you said?
9266.
66, I'm sorry.
And,
Okay.
and we don't,
Thank you so much.
okay, I want you to understand something. We don't get a referral fee. We just give you the lawyer. We don't want a referral fee. We like to service people and help them. Okay?
Very much appreciated. Thank you so much.
You're
Have
welcome.
a great day. Bye-bye.
Good morning.
Hello.
Hi.
I would like for you to give me a number of a lawyer. I am a senior citizen, and I don't have hardly any money, and I would like to know if you can recommend me a lawyer that doesn't pay a high fee because I just don't have the money. I'm trying to get my will done.
Okay, if you call my office, I'll give you the name of the same lawyer. She's a very nice lady. Okay?
Okay, what is that?
You got a pen?
Yes.
It's 248
Yes.
335
335
9266.
9266. 335-9266.
That's correct. And if you call Adrian and tell her you want somebody to help you, we'll get you in hands with this woman. She'll come out and see you. She's just terrific.
Oh, thank you very much.
You're welcome. I'm glad you want to get things in order.
Yes.
Most people, you know, and let me tell you this, they forget to get things in order and then it's too late and then the fighting starts, okay?
Yeah, well, I want to get it in order, but I just don't have the money for these high fees. I can't afford it.
I hear you. Well, that's why I'm going to make sure she helps you, okay?
Okay.
Good morning.
Please call Rushmore Loan Management Services using our toll-free number at 888-504-7200.
I guess somebody snuck in on our line here and wants us to call management service, but we're about giving information, not sharing information like that. Okay, I want to point a few things out to you, and this is a hard sell. I want you to listen to me very carefully. You get a notice in the mail that you have a deficiency judgment against you, and I'll explain it to you. You had a car, your car gets repossessed, they sell the car for $5,000 and you owed $7,000 on it. So you got deficiency judgment of $2,000. You owe $2,000 now plus whatever costs were involved. So you figure they got the car back, you don't pay attention, you don't do anything about it. Then you get a lawsuit, you say, well, they took the car, I don't have any money, and they take a default against you. If you don't answer the lawsuit and the default's taken against you, and you wait more than a year, you're not going to have an opportunity to get the default set aside. Of course, you have to establish cause to set the default aside. So 5 or 6 years go down the road, 7 years, and all of a sudden, somebody files a garnishment against your bank account. And you don't understand why you're being garnished. That judgment's good for 10 years. So if you have a judgment taken against you, you have one of two things. You can sit down and try and resolve the judgment, or you can get it set aside. The judgment, if it's a stale judgment, there's no chance of getting it set aside. I've seen this happen 3 times in the last month where people called me. They came into one of the clinics. We have 2 clinics, one in Brightmoor at City Covenant Church every Friday. This Friday we won't be there because of the holiday and they're closed. And the other one is at Pine Grove Church on Schaefer and Electric on Wednesday afternoon, where we give free legal advice to people. So people come in, you know, lifetime has a lot of challenges for us. Sometimes life is tough and we can't pay a judgment, but that doesn't mean we can't get legal advice so we know what we have to deal with and how to deal with it. So that if we get $1 in our pocket, that dollar isn't taken away because of the judgment when we're trying to get on our feet. So always, and I'm going to say this, always deal with the problem. Don't avoid the problem. Seek legal advice. If you don't know where to get legal advice, you can call my office at 248-335-9266. And we will tell you where to go to get legal advice. Because if you can't afford the services of a lawyer, there are enough institutions out there that receive federal funding that are available to assist you. Thursday, I referred a lady to Lakeshore Legal Services. They've got 13 offices in the Tri-County area to provide services for people who can't afford lawyers. Good morning.
Yes. Could you explain auto responsibility for people that have that money?
Sir, I hate to ask you this. I'm having a little bit of a problem. Either you're speaking too close to the phone or I can't hear you.
Oh, I was talking to the phone.
Okay. You want to call me back and try again? Maybe we can get a better reception. I'll wait for you.
Okay, can you hear me?
I can hear you now. Go ahead.
Yes. you explain that responsibility law with that auto responsibility? I know it's supposed to come into effect October 1st. It's supposed to cancel it.
Yeah,
About
you're talking, I know what you're talking about. You're talking about the auto responsibility. You're going to have to go down to the Secretary of
Yes, I'm
State.
hanging up talking about.
Okay, here's what you're going to have to do. You're going to have to go down to the Secretary of State and the financial responsibility, and you're going to have to go through the process to get a license again. You could do community service and get the license earlier, but if you're going to wait till the beginning of October, you've got to go through the process with the Secretary of State. And what I'll do in September, I'll have somebody on from the Secretary of State to go over all the procedures for the financial responsibility, cover that issue, probably cover it second week of September so everybody gets prepared. So hopefully we'll have all the answers for you at that time. Now getting back to this judgment issue, it's very important to understand that if it's a judgment of record, it's 10 years. And I'm going to warn you about something. When people get judgments, when corporations get judgments, if they can't collect on them, they sell the paper to other companies. Banks do this especially on foreclosures. They sell their foreclosure debt to other companies for 10 cents on the dollar, and those companies try and collect the money. You can negotiate with them. You need a lawyer to help you do it. Good morning.
Good morning. Yeah, I want to talk to the attorney.
I'm right here.
Oh, yes, sir. Yeah, I had this judgment on this apartment building, and the ceiling fell on my head. You know, after I'd been in the apartment about a year. Anyway, December the 13th of last year, we went to court. My attorney showed up, but the other corporation, you know, they own apartment building. They own several different buildings and stuff. But they never showed any interest. They never showed up. So the attorney asked the judge if it was possible could her client have a set-aside judgment? And the judge said, of course. So, you know, $1,000 for the stuff falling on my head. I had to go to the hospital and get some minor surgery done on my elbow. Some debris fell on my, cut me and scratched me a little bit. It turned into an abscess. So this was December the 13th. We were walking out the courtroom. The female attorney turned to me and told me that don't celebrate just yet, because it could take up to 10 years to collect. Now, what kind of hocus pocus? Hello?
Yeah, well, it's not hocus pocus. What she's telling you is that although you have a judgment against them, you still have to be able to collect that judgment.
Yes.
I mean, it's not easy all the time to collect a judgment. And that's what she was telling you. Your attorney should be going forward to trying to collect a judgment against the corporation. If they own the apartment complex, he should be making a claim against them. If they don't pay it, he should be going into court, filing a lis pendens on the real estate and trying to get the real estate for you, and you can sell the real estate.
And you call it a what kind of?
A lis pendens. He should be executing on the real estate. He should be going after the property of the corporation to get you your money if you got a judgment.
Okay, well, this attorney asked me if I could, if members of the owners, of the place, they sold the building, but they're still liable,
Yeah, well, they sold the building before or after.
after, about 5 months after this incident with him.
Well,
He fell on
I-
my head in the bathroom, you know.
Well,
Um,
I think this is what you're going to have to do. Write my number down, and I'll go over
yeah,
the
I got
fact.
it. Got it out.
You got it?
Yes, I got it already.
Okay. Call me on Tuesday, and I'll go over the facts with you and tell you what to do.
Okay, thank you, sir.
Okay, and I'm not going to say anything bad about your attorney, but I'm going to tell you what to do. Okay?
Okay.
Okay.
Okay, God bless you.
Oh, God bless you.
All right.
Okay. Well, I want to thank you all for calling in. I appreciate all the calls today. If you want me to continue on the statute of limitations next week, I'll be very happy to do it, because I think you should all be made aware of what the statute of limitations are for various actions. Until then, I look forward to seeing you and talking with you. And remember, in September, as promised, I will have somebody on early in the month of September from the Secretary of State to talk about these issues. So we'll see you next week. Thank you.